let me tell you, the number of families that come to me afterwards and say, this isn't at all what they thought it was. Hi, Jeff Marsace, the Plain English Attorney, and today we're going to talk about 7 living trust mistakes. And these are big mistakes that I see a lot of people end up doing. So let's go ahead and jump into it after we talk about what is a living trust. All right, a revocable living trust is a way to help avoid probate for your estate. And essentially what you're doing is you're setting up this trust where you're the trustor, you're the trustee, you're the beneficiary. And so you manage this, but when you become incapacitated or you pass on, everything's explained in the trust on someone taking over managing things and getting your assets after you're gone to exactly who you want it to go to. So what are these 7 big mistakes? Top of the list, number 1 mistake, co-trustees. Look, there are different attorneys who are going to have different opinions, but everything that I've seen when it comes to co-trustees, I mean, other than like spouses being co-trustees of the trust they're setting up, it just ends up being a mess, and it ends up being extra paperwork. And usually people are thinking, oh, well, if I have co-trustees, I can spread the work around. The problem is a lot of financial institutions, they don't care if it says somewhere in the trust, oh, any trustee, again, other than the spouses, who they can do whatever that they feel is best on their own. They're going to be like, no. We want to avoid problems. We're going to need both of you to sign. Well, why would they do that? Because sometimes these co-trustees aren't necessarily getting along. One trustee goes in and does something, and it's, well, the document says they do it. The other trustee comes back and it's like, oh yeah, that transfer happened. I didn't authorize that, blah, blah. And it just becomes this huge mess. So co-trustees, it's not something that I would recommend doing. And if you're thinking, well, I want these trustees to kind of keep an eye on each other, you need to get different trustees. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So that's the first big mistake. Second big mistake, not naming enough successor trustees. Now, for my firm and my practice, we really push that you end up having at least 3 trustees listed in succession, so that if anything happens to you, you have enough backups named. Well, why 3? Why not 5? Well, look, if you want 5, that's fine. But what I can tell you is I've been doing this for decades. We've run through 2. We've never run through 3 just yet. So that's just a safe way to build in enough backups. So that's the second big thing. Third big thing, restricting your trustee too much. Now, again, there may be different attorneys with different philosophies. Mine is, if you're going to name a person to be your trustee, you want them to be able to do whatever they feel is best in the best interest of the beneficiaries. You're trusting them to manage things and take things the right way and to do what you wanted them to do. Why would you restrict them? And I've seen a lot of trusts. Well, okay, they can do this. They must do this. They should never do this. They have to do this. Don't ever do this. Once you start putting in all of these restrictions and all they can't do, what it usually ends up being, they don't really trust the person. They just felt like they were obligated to name them as the trustee. Oh, well, obviously my kids need to be listed as my trustees. No, they don't. They don't. You need to figure out who's going to be the most responsible person to be the trustee. Now, check the description below. We're going to have a cheat sheet on naming financial people, which includes your trustee list, and hopefully that will help you look at who should be in charge of your estate plan on the financial end. All right, so what's number 4 for a living trust? Not restricting your beneficiaries enough. And primarily, we're talking about age restrictions. Most of the time, my clients are picking a mandatory age of inheritance of 40. Oh my gosh, Jeff, that sounds so old. Why would you have it restricted until 40? Well, wait. Remember here, you're putting in your trustee choices, people you trust to make really good decisions on your behalf after you're gone. So as long as you're incorporating the authority for the trustee to give the inheritance early, if they think in their judgment the beneficiary is ready for it, well, great. The age of 40 tends to be when most of my clients say, look, if you haven't gotten your act together by the time you're 40, you're probably not going to. So holding that back isn't going to do anything. So that's why we have that upper end of 40. It's because you know your trustee can exercise their judgment and give it earlier when it's appropriate. Now, some other restrictions that should just be in a trust standard is, well, what if they are considered disabled or eligible for Medicaid as their health insurance, and getting some kind of inheritance will stop those benefits? All right, that's a restriction on beneficiaries as well. And for some more advanced planning, we tend to actually use other trusts. We call it in-law planning, in-law protection planning. And this is where you may not want the kids to ever get the inheritance outright. It's in there protected against lawsuits, divorcing spouses, bankruptcy, disability, divorcing spouses, and other things such as divorcing spouses. And I've seen this enough with my clients coming in and having a concern about a son-in-law or a daughter-in-law. So you can build in these restrictions, or the way we do it, we actually have an asset management trust that will take each child's inheritance and lock it up separately so that the money is there for use or to make the big purchases like, oh, they want a big house. The trust can buy the house. So we've got a webinar for that on in-law protection planning. Go ahead and check the description below and it'll get you that web address. All right, so what about number 5, the 5th living trust mistake? Not building in enough beneficiary contingencies. Well, how many should you have? Well, really, it should kind of be to the point where okay, if all of them are gone, I don't know if I care that much. So very typically, I want everything to go, after the spouses, I want everything to go to my kids equally. Well, what if one of your kids passes on before you do, but they have children? Oh, well, we want it to then go to their children, meaning the grandkids get whatever their parent would have gotten. What if they passed on? Oh, well, then it goes to the other children. Oh, what if they pass on? Then it's going down to those deceased child's children, meaning the other grandchildren from those parents. So all of that ends up being multiple contingencies, but then we kind of have to get to the point where it's sealed up. If you run out of specific beneficiaries, a lot of times my clients default to one of two things or a combination. Intestacy. All right, who would have gotten your inheritance if you died without any plan under state law? Now, for North Carolina, this is typically, we're typically excluding in the document saying, okay, we're cutting these people out. Cut out parents, aunts and uncles, and it's about it's a toss of a coin, 50-50. We're including siblings, or they exclude the siblings, so it goes down to the nieces and nephews. So after that, it's first cousins, second cousins, third cousins, fourth cousins, And then after that, we have it written in so that it goes to charities rather than defaulting to the Department of Revenue for the state. So there's a whole setup there, but it's what's in between. Building in at least a couple of layers. If you just say, well, I want everything to go to my kids equally, and that's it. And, well, what if one of the kids dies? Oh, well, we don't even mention it, but they've got kids. You want to make sure you've got enough beneficiary contingencies. All right, so what is the sixth thing? Not funding your revocable living trust. That's a huge mistake, and it happens all the time. Well, why does it happen all the time? Because a lot of attorneys that do revocable living trusts are often just being asked to do it because a client read about a revocable living trust, and now they want to put it together, and it's like, well, okay, yeah, I can create this, but they don't actually do any of the retitling. Now, in fairness, a lot of attorneys don't do that work because it gets to be really, really expensive paying an attorney by the hour to do that when it's just as easy for you to talk with your financial advisor, you to go down to the bank. But I, at least, and a lot of other attorneys, provide the direction. Here's what needs to get done. But sometimes my clients just kind of cut things off once the documents are done and signed. They've gone through the funding meeting with us. Here's what you need to do. Here are the recommendations in writing. And they don't do it. So the best way to think about it is, if your revocable living trust is the best suitcase in the world, it's fantastic. You end up going on that final trip. You end up at your destination. You open the suitcase and there's nothing in it. This is a horrible suitcase. How can you, this is crazy. You don't want this suitcase. No, it's that you didn't pack it. You've got to make sure your assets are lined up appropriately with your revocable living trust in order for it to be effective in avoiding probate. Otherwise, that pour over will that's typically coming with a revocable trust, it's going to mean everything ends up in probate, and the will says, well, then once it's done going through the meat grinder, send it over to the trust. Well, you want it in the trust to begin with, or have the beneficiary set up the right way. So not funding it is number 6, and it's a big and very common mistake. So what is that 7th mistake? Now, this one is a doozy, and it happens all the time, and it creates endless amounts of problems. It's doing it yourself. Let me tell you, the number of families that come to me afterwards and say, this isn't at all what they thought it was. Okay, well, that's because there wasn't a professional helping them, and they either downloaded some forms or did a service online, and it didn't end up being what they wanted. Now, let me tell you, I'm just going to tell a quick story. 2 extremely smart people that became clients of mine. Both of them were PhDs. They kind of handed me their wills that they said another attorney had done. They just wanted me to give it a second look. All right. Went through it, and I said, well, okay, you do realize that you've disinherited each other, married couple. Everything's going directly to the kids. Oh, well, that's not what we wanted. Okay, that's what's there. And you do realize you're not executors for each other either. Oh, no, we wanted each other first in line for that. Well, that's not what's written in here. Oh, and the kids get everything at age 18. Oh, that's way too young. There's too much money for them to take at 18. Well, it says in here that they get it at age 18. That's not what we wanted. All right. Get to the last page. I said, oh, don't worry about any of that. Well, why? Because this isn't a valid will. They had signed their own will, acted as a witness for each other's will, which isn't allowed. It's not allowed in North Carolina. I don't think it would be allowed anywhere where the spouse can be a witness to the will. And it wasn't notarized. There was no second witness either. Oh, well, what, and they actually said this to me. Well, I suppose what we meant doesn't have any weight whatsoever. I'm like, well, it does if it's in the document, but what we just went through wasn't what they wanted. Again, very bright people in their fields, but this isn't something that they do every day. So those are the 7 big living trust mistakes. So if you're going through your plan and you see what you've got, if you've got a revocable living trust and you're like, oh, wait a minute, I have some of these mistakes, it might be time to go ahead and get a little update and some amending done. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.